Day after the election of 2022 meeting of the Maryland National Capital Park and Planning Commission. Could I get a motion to approve the agenda, starting with the Prince George's members, please?
Move approval, Mr. Chairman.
Second,
Commissioner
Mrs. Bailey.
All in favor on the Prince George's side?
Washington, aye.
Bailey, aye.
Mr. Chair, I'm sorry if I could interrupt. There is an addition to the agenda of the General Counsel's edition of the resolution.
Okay, unless there's an objection, I'll take that
2252.
as a motion to approve the agenda as amended.
Thank you.
Could I get the ayes on the Prince George's side?
Chair Washington, aye.
Bailey, aye.
And I see
Shapiro,
Manny,
Commissioner Giraldo, you're on mute.
yes, I see Manny Giraldo is raising his hand to indicate aye, even though he is.
Aye.
There we go. Thank you. And Mr. Shapiro. Yeah. Okay, and we don't have Will, do we?
No.
No,
Yeah.
we did not.
Okay, the Montgomery Commissioners.
Jerry Sushi, aye.
Tina Patterson, aye.
Okay, so that's unanimous. Could I get a motion to approve the commission minutes of June 15th, both open and closed session?
So move, Commissioner Giraldo.
Second, Bailey.
All in favor, starting with our Prince George's friends.
Giraldo,
Bailey,
aye.
aye. Bailey, aye.
I got Giraldo and Bailey.
Washington, aye.
Shapiro, aye.
And Montgomery County.
Jerry Sushi, aye.
Chair, I have to split my vote. On the open, aye. On the closed, I have to abstain. I wasn't present for part of that discussion.
Okay, so I'm going to treat that as unanimous on the open session and 6-0 to 1 on the closed session, unless legal tells me I need to do that differently, or there's an objection. The record will reflect a different vote on the open and closed session. General announcements. It's Bereaved Parents Month. It's also we've got Hispanic Heritage Month coming up. I'm sure there will be many amazing events to celebrate Hispanic Heritage Month. So stand by your email inbox for news about those. We have some committee minutes and board reports that are from information only in the packet, including the executive committee meetings of July 6th and the ERS meeting of June 7th. That brings us to action and presentation items. Is there a presentation, or just are you looking for a motion, Mr. Cohen, on Resolution 2227, the Prince George's County bond sale?
Good morning, Mr. Chair. Just looking for a motion, and just wanted to thank yourself, Vice Chair, and Ms. Borden for helping getting the resolutions to their current form. Thank you.
Very good. Is there a motion to approve that bond sale?
Move approval, Mr. Chairman.
Second,
All in favor, starting with Prince George's County?
Washington, aye.
Bailey, aye.
Giraldo, aye.
Shapiro, aye.
And Montgomery County?
Jerry Sushi, aye.
Tina Patterson, aye.
And Anderson is aye, so that's unanimous. Again, for Resolution 2228, Montgomery County bond sale, could I get a motion to approve that?
Jerry Sushi, motion to approve.
Giraldo, second.
All in favor, starting with the Prince George's Commissioners?
Washington, aye.
Bailey, aye.
Giraldo, aye.
Shapiro, aye.
Montgomery County?
Jerry Sushi, aye.
Tina Patterson, aye.
And Anderson, aye. So that's unanimous. Resolution 2229, Adelphi Road, UMGC, UMD, Purple Line Station. Is there a presentation, or are you simply looking for a motion to approve this? Anyone from Prince George's Planning?
What is it?
We don't have any presentation. We are just looking for approval.
Okay, could I get a motion to approve Resolution 2229?
Move approval, Giraldo.
Second, Washington.
All in favor, starting with Prince George's.
Washington, I.
Bailey, aye.
Giraldo, aye.
Shapiro, aye.
Montgomery
Sure.
County.
Jerry Sushi, aye.
Tina Patterson, aye.
And Anderson is aye. Resolution 2230 is to adopt the Bowie, Mitchellville, and vicinity master plan. Do we get a motion to approve that?
Move approval. Giraldo.
Second, Washington.
All in favor on the Prince George's side.
Washington, I.
Bailey, aye.
Giraldo, aye.
Shapiro, aye.
And Montgomery County.
Jerry Sushi, aye.
Tina Patterson, aye.
And Anderson, aye. So that's also unanimous. Congratulations on adopting another new master plan. Resolution 2231, disposition of a lot on East Lane in Montgomery County. I think Henry Coppola is here, but we probably just need a motion to approve that. But Henry,
Jerry
Yeah.
Sushi, make a motion to approve.
is there a second?
I'll second it. Giraldo.
All in favor from Prince George's?
Washington, I.
Bailey, aye.
Giraldo, aye.
Shapiro, aye.
And on the Montgomery County side?
Jerry Sushi, aye.
Tina Patterson, aye.
Anderson, aye. Amendments to practice 6-40, which concern commission sustainability policies. Mr. Beckham, is there a presentation or are you just looking for approval of these amendments?
Yes, good morning. We do have a presentation prepared, but if the commission would like, we're also happy to forego that and just ask for approval of changes to the practice.
Okay, perhaps you could just give us a short summary rather than going through the whole blow by blow.
Sure, I'll turn it over to Michael Dokes, who was lead on changes to this policy. Michael, you can pull up the presentation if you like, but just walk quickly through the high level changes.
Sure. Good morning, everyone.
Good morning.
So I'll make this a shorter presentation than we have been. I have on the screen PowerPoint for the Sustainability Practice 640. Can everyone see it?
No,
we don't.
no.
It's not up.
Okay. Not up. Let me do a share. Sorry. Can everyone see it now?
Yes.
There you go.
Yes, sir. We can see it.
All right. So essentially, practice 640, the sustainability practice, it has to do with the commission's long-held commitment to being a good environmental steward. It contains the strategies, goals that both the Prince George's as well as Montgomery County, who come together to develop the practice and the plan, their commitment, both counties' commitment to use human, monetary, and physical resources, capital resources, in a responsible way to protect the environment. The policy office, together with the sustainability committee, comprised of representatives from the planning departments and the parks department in Montgomery and the planning department and DPR in Prince George's County, comprise the sustainability committee. Very quickly, just to point out some very high level changes that are being made that we're proposing. They're heretofore, and maybe I'll just shoot down to, well, let's go down to, since I'm going to skip the history.
Yes, please.
Yeah. Let's see what makes sense here. Oops, sorry about that. I was looking for a particular slide. Well, let's go with this one. So the Practice 640 currently it has a number of very specific detailed goals in it. The opinion and the concern with the sustainability committee was that those goals and those targets that are contained in the previous practice have come and gone. And over time, the industry has changed. There've been, this practice started out as being about fuel and motor oil and that sort of thing back in 1987 when it was originally approved. And now there was a major change in 2012 to bring the policy up to date with a green building, the LEED certification, leadership in energy conservation, in energy, environment, and design, and also to comply with laws that had been passed by the state as well as both counties dealing with things like soil conservation, water conservation, erosion, and that sort of thing. So there was a major update in 2012. Now, spring forward in 2020, the emphasis has changed once again. Now the emphasis has shifted to climate change. For example, also concerns about environmental justice. And so what we've done with this practice is, one, we've said, let's move the specific details that would be that are in the practice itself that are subject to change, and instead put those details in plans, with sustainability plans that we're proposing be developed over a 5-year period. Previously, they were developed over 2-year periods, and then they were reported out to the executive committee and the commission upon request. The proposal now is, let's shift that to 5-year plans. One, to give more time to develop it, and at 2-year intervals, progress toward the 5-year plan would be reported out. So the short answer of this is that in the current, as you can see in the depiction in the slide, the current situation is that there are prescriptive practices and quantitative goals, and our proposed kind of captioning and descriptions in the practice, at least, would be emphasis on things like climate change, green building, DEI, which is diversity, inclusion, and diversity, equity, and inclusion, which is a pretty interesting, I do want to hit on that addition that we've added, and long-term performance of the commission as opposed to short-term goals. And so the practice, this is the slide I was looking for earlier. The practice heretofore, as it's currently drafted, has 6 areas, and they all, except for the last 2, deal with science and environmental issues. What we've done is take the first 4 bullets that deal with physical and environmental science, and we put them in one area called environmental responsibility. And we've expanded the practice beyond just the science to talk about social justice, which is, as I'm sure people are aware, the commissioners are aware that the environmental justice has become a forte. The Department of Justice, the state, all have placed emphasis on the environmental justice area. So we've included language in the practice saying that although we know that the commission has always been a friend of fairness and diversity, we know that, but it has not heretofore been specified in its policy. So we put it in here to bring the policy up to date with that concept. Economic vitality, a bigger emphasis on that, and that has to do with making making sure that what is being proposed is economically feasible. It also has a diversity component in that category to make sure we're reaching out to vendors, minority, women, veteran-owned, and persons with disabilities. That we're diverse in terms of our economic outreach when it comes to procurement. And I'll do one more, perhaps just to give an idea. Well, I don't do this. What I'm going to do, I'm going to stop here. I think I've covered these areas pretty well. I'm going to let the Sustainability Committee, who are on the call, if you don't mind, I want them to have an opportunity to describe how they're going to go forward now in terms of developing the sustainability plan. And they'll go into just, if you would, I think Amanda and from Montgomery County, Aparicio, I hope I pronounced the name correctly, and Lauren Bell from Parks are on the call. And I do want them to just take 5 minutes, if they would, and talk about how the sustainability plan is going to be developed and a little bit more about what's proposed.
Sure. Thank you so much, Michael.
Mhm.
So basically what we are trying to achieve here is,
Did everyone else mute that we're getting an echo?
thank you.
I'm going to mute.
Basically, through these revisions, we really want to allow Practice 640 to serve as a guiding framework for the development of our sustainability plan. Previously, the way that the practice was written, it was written more like a sustainability plan that called for us to develop a sustainability plan. So what we're trying to do is allow that practice to serve as that guiding framework, and allowing the practice to then withstand changes in regulations, policies, industry standards, and technology over time, which we've seen since 2012 to now. This will allow our future sustainability plans to then intercept all those changes over time, serving more as a living document, which allows us to continue advancing the organization along the very latest in the sustainability field. So what we've done in the practice is establish a set of broad focus areas under 3 pillars: environmental responsibility, social justice, and economic vitality. Much, if not all, of the things that were in the old practice are still touched on in the new practice. It's just sort of reformatted a little bit, because we're going to go into a lot more detail than we've done previously in the sustainability plans for how we're going to set goals, have quantitative and qualitative metrics, and sort of progress the organization forward. I don't know that we need to get into all of the detail there unless there are more questions, but we are already in the process of engaging staff across across the entire agency, really, in the development of this newly updated sustainability plan, which again, as Michael said, will be a 5-year plan instead of a 2-year plan. The thing that we've ran into over the past few years is once we get the 2-year plan set, it's time to start writing the next one. And a lot of, sustainability initiatives are longer term projects. And so we think the 5-year plan is more appropriate in this case. So with that, I don't know if anybody has any questions. Be happy to answer them.
Are there questions for the sustainability team? And if not, is there a motion to approve the amendments to Practice 640?
Jerry Sushi, I'll make a motion.
Washington, second.
All in favor, starting with Prince George's County Commissioners?
Washington,
Mr.
aye.
Chair, I have a question.
Oh, yes, Manny.
I'm sorry. Right now, we're supposed to do a new plan every 2 years, and it's going to 5 years. Is that realistic given the way climate change is happening so rapidly?
Well, so that's the other thing, and that's a really good question. So, we set the 5-year plan, we set a path forward, which it may go even further than 5 years in the way that we establish some of those goals, really depending on the focus area. But by housing all this information in the plan rather than as detailed in the practice, we're able to shift with changing in regulations, changing with science, as this field sort of develops even further, we have a little bit more room to make this program even stronger over time. So
it's more fluid.
Yeah, absolutely.
Okay.
That's a really great way to think of it. Mhm.
I'm fine. Thank you, Mr. Chair. Thank you so much.
Absolutely.
Jerry Sushi, on that basis, maybe you could have a 2-year milestone, 5-year, 10-year, et cetera.
We do have a 2-year progress report. Every 2 years, you guys will get an executive summary towards progress towards those 5-year goals. So if we do need to pivot or shift within that 2-year period because of advances in technology or science, you'll get apprised of that.
Okay, thank you.
Okay, I believe there was a motion and a second to approve these amendments. Could I get All those in favor, starting with Prince George's Commissioners.
Washington, I.
Bailey, aye.
Giraldo, aye.
Shapiro, aye. Let me just explain my vote real quick. I just want to thank the staff for all the excellent work that's been done on this and the regular communication, and I'll leave it at that, Mr. Chair.
Very good. Montgomery Commissioners.
Jerry Sishi, aye.
Tina Patterson, aye.
And Anderson is aye, and I definitely agree with Chair Shapiro that this is an improvement on the previous practice, both in its substance and the way that it's structured to be more flexible and designed to allow evolution over time. So thank you all for your work. We can turn now to 5G, incentives for COVID boosters for employees, with the Executive Director and/or Mr. Beckham to briefly explain this.
All right, Mr. Beckham, why don't you go on ahead?
Yes, thank you. So this item was sent as a late delivery item via email, and it is about encouraging COVID-19 booster shots. So we know that employees getting boosted, that helps them stay healthy and prevent them from getting seriously ill from COVID-19. And so we were directed by leadership, by the executive committee and department heads to create a framework to incentivize employees to get those booster shots. What's shared with you is a memo, a draft notice, and then a guideline document that will help employees know what to do when they become sick or when they get exposed to COVID-19. And just to cover the framework of this notice to incentivize those booster shots, employees through the end of the calendar year, non-represented merit system and term contract employees will be able to receive administrative leave if they become sick from COVID-19, if they have a breakthrough case, and if they're instructed to stay home and not work by their medical provider. Now, employees will be required to provide medical documentation from their medical provider that they have been directed to quarantine and to not work. If an employee is still able to telework, we want employees to continue to do so. When this notice is issued, employees will be required to disclose their booster status within 30 days. That was required by department heads. So in doing so, we're going to be able to know the status of our employee population, whether or not they are boosted or not. So the draft notice is provided in the attachment that was sent, which covers those things that I mentioned. The policy for employees represented by the McGeo and FOP unions will be communicated once an agreement has been reached. And I want to briefly show the guidance document that was created. This covers 4 different scenarios to help employees know what to do when they become exposed or when they're sick to COVID-19. In the first scenario, if an employee is out sick, but they have not tested positive for COVID-19, they're directed to communicate with their supervisor. They're encouraged to contact their medical provider and to remain in contact with both. If an employee is not directed by their medical provider to quarantine, they should be using their own accrued leave. It could be sick, personal, annual compensatory leave. And it's also noted that unused social distancing leave may be used through the end of the calendar year. You may recall that a notice went out extending the availability of this for individuals who still have an unused balance of social distancing leave. In the next scenario, if an employee tests positive for COVID-19, they are, of course, directed to contact their medical provider, provide their supervisor with an update, and to follow the guidance from their supervisor on their work schedule and status. Employees who are fully vaccinated and boosted, they may receive administrative leave when they're unable to work on site or telework, and also when they're directed by their medical provider to quarantine and to not work. And a note is given to the notice that will cover the eligibility and medical documentation requirements. Scenario 3 is very similar in process as to what to do. In this scenario, it would be if the employee is in direct contact with someone or exposed to a positive COVID-19 test. And again, if they are fully vaccinated and boosted, and they are directed by their healthcare provider to not work and to quarantine, they may request that administrative leave. In the 4th scenario, if the employee has been under quarantine and they meet those return to work requirements, they are instructed to notify their supervisor of their intent to return to work. And when an employee is fever-free for 24 hours without the aid of fever-reducing medication. And when their symptoms have lessened, they are able to return to work. And at the bottom of the guidance document, the website for the CDC is provided, as well as the number for the risk management and safety team's 24-hour hotline. I'd be happy to take any questions you have, but we wanted to share this with commissioners to let you know that we will be issuing this to employees to help them if they have a breakthrough case and they need to stay home in quarantine.
Commissioner Washington has a question.
Yeah, go ahead. I have a little bit of a friendly amendment here, but go ahead with your question and we'll see how that connects.
Oh, okay. And it is specifically related to, it seems that there is a requirement to be directed by an individual's medical provider. And I'm questioning, because the availability of home tests, and people take tests all the time and then they might just want to follow CDC guidelines. I mean, have we considered that or thought about that, or we're just making?
Actually, my amendment concerns just that very subject. So I don't want to interrupt you, but I was sort of thinking the same thing, and I'd been in conversation with some of our the folks drafting this policy because I was concerned that we insist on documentation. That's why the policy, as it's drafted, includes all those references to direction from your doctor, basically, and documentation. But as we were sort of thinking about this, I think the concern that you've raised, Shanice, is I think was also shared by some of our management folks in the departments, and I think those concerns are well taken. What I would suggest is that we modify this to say that you either show you are directed by your medical provider with appropriate documentation, or by risk management or other appropriate commission authority. So that way, if you show up with a positive test, maybe you took it at home, maybe it was administered for some reason in the workplace or otherwise, if you show the appropriate documentation and the commission concludes that you don't belong in the workplace, we are not going to make you go get a note from your doctor, which I think is where you're going with that, if I'm understanding you correctly.
You absolutely are. Thank you, Mr. Chairman.
Very good. So I would consider that a friendly amendment to this. To
the motion I'll make for approval.
Very good. Unless there are other questions or comments, that would be excellent.
Yeah, I do have a comment. There was the provision that was requested by the directors that if people were able to telework, that they should not be given leave. And so it then becomes very onerous and difficult for risk management or so to decide whether somebody can telework or not based on the jobs. If you make such an amendment, we base this off of what Montgomery County is doing to provide leave. We can do something different, of course, but I just, if we do that, what I'm saying is that risk management will probably just grant people, if they're the admin, say, okay, fine, because they can't really identify whether someone can telework or not.
Well, I think the commission, meaning us, the collective we, needs to be able to coordinate with risk management. I don't think it's really satisfactory for risk management to say, well, we can't know whether this person can telework, so we can't figure out whether that they should be on leave or not. I think we need to write this in such a way that it's clear that you need that what we're talking about here are people who cannot and should not be working in light of their duty assignment as well as their health condition. So if that means that the relevant supervisor needs to coordinate with risk management on whether or not an employee can or should be teleworking, then I think we need to do that rather than just say to people, well, you're teleworking and you're not symptomatic, but we've told you to take a week off. I mean, that doesn't make any sense. Right? Like, you could be exposed and you could have the need to quarantine, and yet you wouldn't teleworking, so why wouldn't we ask you to keep working?
I agree. And at this point in the whole COVID dynamic, if you will. We ought to know who is able to telework or not as it currently stands, right?
Yeah, I agree.
Well, it's not based on whether they can or have the option to, it's how sick they are, right? And that's what the doctor determines. Somebody could telework, technically, we allow them to, but they may not be well enough to telework. And that's what I'm saying is that risk management are not medical people, they can't make that determination.
Well,
I
I
kind
think
of
that
agree.
the policy needs to reflect the fact that if somebody is telling us there's two things going on here. One is we don't want them in the workplace because we don't want them spreading COVID to other people. The other one is that they are ill and therefore they're unable to perform their job duties regardless of whether they're infectious or not. And I just think the policy needs to address both those points, much in the same way we routinely address people's illnesses that are not related to COVID, where we say, if you're too sick and you shouldn't be working.
Right.
Right?
Yeah, I think if I can just help a little bit with this is Deborah Borden, Acting General Counsel. I think we're making this a little more complicated than it has to be. Our regular sick leave rules should just apply. If a person is sick, they tell you they're sick, they can't work, and they can telework, then they should be telling that to their supervisor. Okay, if they're too sick to telework, again, that should be a conversation with the supervisor, just like it is any other time that anyone is sick, no matter what the illness is. And if they need more than 3 days of sick leave because they are sick and they cannot work, then again, the same process should kick in where they need a doctor's note to tell us that they are sick and they cannot work or telework in any form or fashion. So in order to use this leave, you should have to be sick or your job does not allow you to telework and you cannot come to work. So, it's the same situation and we shouldn't recreate the wheel. We should use the same rules that we have now. There shouldn't be any reason for someone to show us a doctor's note if they're telling us they're sick and they only need a couple of days off. Okay? Would that work?
I agree with that.
I mean, I think that's on point. I think all we're doing here is giving people a little bit of an incentive to get vaccinated, because if they wind up getting sick, despite the fact that they're vaxxed, we're going to basically say, if you can prove you got COVID, despite the fact you were vaxxed and you need to not be working and or in the workplace, then we're going to let you take some leave that's not coming out of your normal leave. That's the little carrot we're giving here for people to get vaccinated. That's the only way in which I think this should deviate from the standard sick leave policy. And I think that that's consistent with what Ms. Borden is saying.
Yeah, I can work with Mike's team to, adjust the language so that we get to what you're talking about. We can do it.
I think Director Sheckley had her hand up.
Andre, did you want to say something?
Just a question. Thank you so much, Mr. Chair. So we're just going to accept people's word that they have tested positive?
No, we're saying that we can ask for documentation of that, but ultimately we may not ask them to get a doctor's note. There may be other documentation that's sufficient, like they may be able to show us a positive test. Doesn't necessarily mean they went to a doctor's office. Like I can walk across the street here to Wheaton Mall and get a COVID test. If I test positive at lunchtime, come back with my positive COVID test, I can call risk management and say, hey, I tested positive. I don't, think I should be in the workplace and I can't telework. So risk management, my supervisor could say, yeah, you're right. Go home. You can take a couple days of admin leave, etc.
Maybe I'm just a little cynical, but how do we know it's their test?
Well, I think what we're saying is that there's other ways to document this, not necessarily your doctor. Sometimes we would give sometimes it'd be that we would give the test.
Okay, thank you.
Yeah, I think that's what, I guess Andre is getting the point that we heard from the directors, is that they were just concerned about people saying, oh, I tested positive from a home test, that they wanted to have some sort of documentation about that. We can modify about quarantining and getting that medical documentation, but they wanted something a little more substantial than just saying, oh, yeah, I tested positive on a home test. So we'll work with legal on that and with the directors as well to update so that.
I was just going to add to that, and I certainly understand and appreciate the concern, but to me that gets to a larger issue. You know, I mean, we can apply that same scenario to any potential sickness, you know, or I broke my leg or my ankle. I mean, you know, how are we handling it now? I think that Council Borden said it very well. Let's not overcomplicate it. And I think supervisors, if they should have some idea or some awareness of, you know, the intent behind an employee. And if it becomes a pattern, then it's a bigger issue than incremental COVID leave.
Well, respectfully, I think that with the way things are right now, employees would have to use their own leave. Whereas with this, we're saying we're going to give them administrative leave. So when somebody knows they have to use their own leave, they're a little more judicious. That just.
And I believe, Cynthia can correct me if I'm wrong, but I believe our current practice is if you call in sick, we reserve the right to ask you to document that. We don't necessarily insist on it in every case. Like if a manager gets a call from somebody they supervise, says, hey, I'm sick today, they're not necessarily saying, I want to see a doctor's note. But if for whatever reason we were suspicious that somebody was falsely claiming to be have some medical problem, I believe the current practice allows us to ask them to prove it.
That is correct.
So this is really in line with that, and I think what Ms. Borden was suggesting is that she'll work to conform this to that practice to make this as much like any other sick leave situation as possible, with the minor difference that we're allowing people to use a different category of leave that doesn't come out of their time.
Okay, we'll work with legal to conform to the current policy, and we will get that out shortly.
Okay, could I get a motion to approve these incentives for COVID boosters?
Move approval, Mr. Chairman, taking into account the discussion just taken, conversation we just had.
Second, Commissioner Giraldo.
All in favor, starting with Prince George's.
Washington, aye.
Giraldo, aye.
Dorothy Bailey is still on mute. I see her mouth is moving, but I'm not hearing what she. I'm gonna take that waving of the hand as an aye.
And I vote Shapiro, aye.
Very good. Montgomery County Commissioners.
Jerry Sishi, aye.
Tina Patterson, aye.
And Anderson is aye. Thank you all for working all this out.
Thank you.
Now we need to talk about the Open Meetings Act briefly. And as some of you know, we recently received an opinion from the Open Meetings Compliance Board on June 30th in response to a complaint about some of our open meetings practices. According to that opinion, the Commission violated the Open Meetings Act by failing to prepare sufficiently detailed closing statements and closed session minutes, and found the Commission erred when it failed to cite a statutory exception before going to closed session. And as the Chair of the Commission, I'm obligated to provide the summary of this violation, which is what I'm doing right now. And I acknowledge, as does the Commission, that we received the board's decision and we continue to believe in the importance of open government, including but not limited to compliance with the Open Meetings Act. I am going to say a couple of additional things, however. I encourage all of you to read this opinion if you have not already. I think it is weakly reasoned. I think it is lost not only the forest for the trees, but in some cases the trees for staring at the leaves on the trees. I find some of the interpretations of the act and the application to the alleged violations to be plainly incorrect. And while we respect the Open Meetings Compliance Board and the Open Meeting Act, I do not believe that we would be serving the public well if we did not note that the interpretation that is being applied by the Open Meetings Compliance Board, I do not believe serves the public well or serves the interests of open government. For example, the commission is permitted under the Open Meetings Act to conduct collective bargaining negotiations in closed session, including matters related to those negotiations. And the reason that we're allowed to do that is because it's important to have confidential discussion of our bargaining position. According to the Act, before we go into closed session, the commission is required to identify the topic of the closed session, and the statute uses that word topic. The commission informed the public on its agenda, as well as orally through my statement at that meeting, every time it entered closed session in 2021, when it was intending to engage in the discussion of collective bargaining. The Open Meetings Compliance Board nonetheless found that we violated the act because the topic failed to also include the name of the bargaining unit. In other words, the board opinion says that the topic of collective bargaining is not sufficient to say that we're talking about collective bargaining in closed session, but that we had to name the union that we were negotiating with, which in our case is sometimes the Fraternal Order of Police and sometimes it's McGeo. Reasonable people, I suppose, can disagree, but I think the problem is that by finding that we're in violation of the Open Meetings Act based on the failure to say we're going to talk about collective bargaining with McGeo versus we're talking about collective bargaining with the FOP is not only a hyper-technical violation, which is not supported by the plain meaning of the word topic in the Open Meetings Act, but by going further and reading into the Open Meetings Act requirement, which is not clearly spelled out, I think that the board actually undermines public confidence in open government because it suggests in a way that I don't think is a fair and accurate characterization of the way that we handled these closings of open meetings to talk about collective bargaining, that we're doing something in secret. Because most people who hear about the fact that we were found to have violated the Open Meetings Act are going to assume that we were trying to do something behind closed doors that was not appropriate. And that's not what happened here. It's not what the allegation claimed, and it's not supported by the facts of this case. I'd also point out that a separate part of this opinion found that the Employment Retirement System Board violated the Open Meetings Act because they discussed administrative matters in a way that was not consistent with the Open Meetings Compliance Board's interpretation of the word administrative, which is an exempt category of discussions which are allowed to happen outside of an open meeting. I'll let you read the opinion so you can judge for yourself, but I think what you really need to know about this is the result of the Open Meetings Act Compliance Board interpretation of the administrative topics exception is they said ERS can talk about the policies and practices that they apply to investing retirement funds, which I think in our case is, it's hundreds of millions of dollars, that those are appropriately discussed in closed session because they're administrative. But the ERS cannot talk about certain personnel matters like how much leave they're providing to employees for COVID social distancing because those are not administrative. So the result of this decision, if you take its logic to its conclusion, is that ERS can talk about how it invests hundreds of millions of dollars in pension funds in closed session outside of public view because those are administrative, but it can't talk about whether or not we're going to give Andrea Rose an extra day off because of COVID. And I submit to you that that's a perverse result that does not serve the public interest, that does not serve the interest of open government, and I believe this decision is simply off base in many very important respects. So we accept accountability when we make a mistake. And the reason I'm required to read this statement under the law is because the legislature has concluded it's important for public bodies like ours to take responsibility to acknowledge when we've erred in public. And I embrace that. But I also believe the Open Meetings Compliance Board should be accountable for the consequences of the interpretations of the law that they make. And when they are off base, as I think they were here, I think they should be required to confront the fact that they're simply interpreting the act in a way that is not helpful to the public interest and creates a false impression that something is been done that's inappropriate when in fact it is not, and that is not supportive of public confidence in government. So that's what I have to say about that. If anybody wants to make any comments, that's fine. I don't expect anybody to agree with me or disagree with me. You're free to express your views on this, but that's where I am, and I thought it was important to say that in public. So, if there are no other comments on that subject, we can move to the officers' reports, most of which are for information only, but I think our general counsel would like to.
Item 5I, which is the late delivered resolution.
Oh, 5I is late delivered resolution, which is which one?
The appointment of Deborah.
Oh, I'm sorry. We have a late delivered resolution. The two chairs have reached consensus that we should appoint Ms. Borden, general counsel, permanently subject to negotiation of an employment agreement with her. And we hope that the full commission will support that proposal, and that is
resolution number 22.
Resolution 22-32. Are there any questions or comments or a motion on that resolution?
I enthusiastically move.
Second.
In favor.
Okay, there's a motion and a second. All in favor on the Prince George's side.
Washington, aye.
Enthusiastically, aye.
Giraldo, medium aye.
Shapiro, aye.
Okay, on the Montgomery side.
Jerry Sishi, aye.
Tina Patterson, aye.
And Anderson is definitely an aye. So that's unanimous. Congratulations, Ms. Borden, and we will be working with her on an employment agreement and hopefully get that wrapped up promptly.
Thank you, commissioners.
Thank you very much. We look forward to working with you for a long time as you continue your contributions in your career at the commission. Okay, officers' reports are for information only, but I believe our general counsel would like to have a word.
I would, and good morning. Thank you, Mr. Chairman, Mr. Vice Chairman, and members of the commission. For the record, my name is Adrian Gardner, and I really wanted to just take about 60 to 120 seconds to say thank you to a few folks. This is my last commission meeting. This is going to be my last full commission meeting, as you know. I have just gone through a period where my mother was dealing with an extended illness, and she passed about 3 weeks ago, and this is my first week back. I wanted to take a moment to say how important it was to me and to my family, and I want to thank Chairman Anderson, former Chairman Hewlett, and of course Vice Chairman Shapiro for supporting me in giving me the space and the allowance to go spend the time with my mom and my family. That made a tremendous difference. You know, we have these policies in place, and you never know if you're really going to be able to avail yourself of them. But in that regard, I just cannot tell you how invaluable that time was, and how much we really sincerely needed it, and it made a big difference. The second thing is I want to thank you again and the commissioners and so many of my colleagues who have reached out to send their condolences to my mom about my mom's passing. And you know, we talk about the commission family, and sometimes family imparts a couple of different dimensions. But this one is a scenario where I really did feel the love. Thank you for the cards, the letters. I will get around to each of you individually, but I wanted to publicly acknowledge how important that was and how much and how meaningful it was for people who were able to stop by and see her service. And finally, I really want to acknowledge and thank and continue to thank the work and for her tireless efforts, Deborah Borden. You guys just made a fantastic decision. I could not have even considered, I think, doing this, sort of leaving my baby of 22 years behind, were it not for the level of confidence that I had and continue to have in Deborah. We just saw how her acumen can help simplify things and make things so straightforward. She knows that part of this, the sort of the central core of my succession plan was to have a good, solid, strong deputy. And I would like to take a little bit credit as well, because I think it has worked and it it will continue to redound to our agency's benefit. That was more than 120 seconds, but I want to say thank you for letting me get that off of my chest. And it's so good to see all of you, at least on the screen.
Very good. Well, I'm sure we're going to have a proper send-off for Adrian, so there's no need for tearful goodbyes just yet. If anybody needs to say something right this second, we can certainly accommodate that, but I just want to make sure everybody knows that this is not your last chance.
Not your last hurrah.
Exactly.
Very good. Thank you so much for that. And we will have a big celebration as befits your long and really sterling service to the commission and to our community. Yes. Applause, thumbs up, and hearts. All those emojis. Yes. All right. It's time to go into closed session. Pursuant to Maryland General Provisions Article of the Annotated Code of Maryland, Section 3305B, 9, and 15, to consider matters relating to negotiation over collective bargaining and cybersecurity. And I'm going to point out that this closed session notice, according to the Open Meetings Compliance Board, is not compliant with the law because it doesn't say which union we're going to talk to. So I'm just going to say, really, this is going to be, I think, primarily about McGeo. It may implicate FOP, but I think you can kind of see the point I was trying to make earlier about how this is really not particularly helpful to the public at eliminating what's going on in closed session or the degree to which that's appropriate or inappropriate. But we will cover ourselves and comply with every aspect of the law as the Open Meetings Compliance Board has interpreted it, and say we are going to talk about collective bargaining, which may encompass matters related to both of our unions, as well as the CIO's report on cybersecurity. Is there a motion to approve going into closed session on that basis?
So move. On that basis.
Washington second.
All in favor on the Prince George's side?
Washington, aye.
Bailey, aye.
Giraldo, aye.
Shapiro, aye.
Montgomery.
Jerry Sishi, aye.
Tina Patterson, aye.
And Anderson, aye. We'll see you all in a minute in closed session. Thank you all.
If I can find it. Okay.